said countdown.
Okay, please go ahead.
We will be live in 5, 4, 3, 2, 1.
Good morning. Today is Thursday, May 6, 2021. This is the continuation of the Nevada Gaming Control Board meeting for the month of May. Today on our agenda, we'll be covering items from continued from yesterday's agenda: restricted items, new devices, new games, casino player dispute appeals, and regulations. Madam Secretary, did we continue any items from yesterday's agenda?
No, we did not.
Okay, thank you. Madam Secretary, let's proceed with the items on our restricted consent agenda. And these were items with no questions or issues associated with them, and no appearances were required.
First item is restricted number 4, which is the application of Aloha Jones Inc. doing business as Jackpot Bar and Grill for restricted gaming license, and the applications of Maria Ochia and Jeffrey Frederick for licensure as an officer, director, and shareholder. Restricted 5 is the application of Akeem Inc. doing business as 7-Eleven store number 15478 for restricted gaming license, and the application of Suhinder Maruk for licensure as sole officer, director, and shareholder. Restricted 6 is the application of Nimbus Inc. doing business as 7-Eleven store number 29638 for restricted gaming license, and the application of Suhinder Maruk for licensure as sole officer, director, and shareholder. Restricted 9 is the application of Crawford Coin Inc. doing business as Green Valley Grocer number 70 for a waiver of Nevada Gaming Commission Regulation 4.080 as noted on the agenda. Restricted 10 is the application of Crawford Coin Inc. doing business at Green Valley Grocer number 67 for a waiver of NGC Regulation 4.080 as noted on the agenda. Restricted 11 is the application of Jet Gaming LLC doing business at Terrible's Market number 415 for restricted gaming license. Restricted 12 is the application of Sartini Gaming LLC doing business at El Dorado Cantina for restricted gaming license. And restricted number 13 is the application of United Coin Machine Company doing business as Century Gaming Technologies doing business at Square Bar for restricted gaming license.
Okay, thank you very much. Any discussion on these items, members?
None for me.
Okay.
Not for me either.
Thank you. Would either of you like to care to make a motion?
Certainly, I will do that.
Okay.
Chair Gibson, I move to recommend approval of restricted agenda items number 4, 5, 6, 9, 10, 11, 12, and 13 as read into the record by Secretary Bell, with the following conditions to apply as follows. For item number 4, a sign of appropriate size, which has been administratively approved by the Nevada Gaming Control Board Chair or the Chair's designee, must be at the entrance to the location indicating that the slot machines are available to the public to play and that patrons are not required to pay a cover charge to engage in gaming. For item 4, again, if an equity owner is no longer functioning as a key employee for this location, a key employee application must be filed within 60 days and thereafter be refiled within 60 days of any change in the person occupying that position. For items 5 and 6, if an equity owner is no longer functioning as a key employee for this location, a key employee application must be filed within 60 days and thereafter be refiled within 60 days of any change in the person occupying that position. For items 9 and 10, the waiver of the provisions of NGC Regulation 4.080 in conjunction with the approval granted in November 2020 shall expire on the date of the regularly scheduled NGC meeting in November of 2021. For item 11, a cashier age 21 or older must be on duty at all times. The machines are available to the public for play, and the surveillance system and or mirrors must be inspected and approved by the Nevada Gaming Control Board Enforcement Division within 60 days of issuance of the state gaming license and thereafter be maintained at or above the standard that is approved. And lastly, for item number 13, a sign of appropriate size, which has been administratively approved by the Nevada Gaming Control Board Chair or Chair's designee, must be at the entrance to the location indicating that the slot machines are available to play to the public to play and that the patrons are not required to pay a cover charge to engage in gaming.
Okay, thank you very much. Madam Secretary, please.
Member Watkins?
Aye.
Member Katsaros?
Aye.
Chair Gibson?
Aye, thank you very much. Madam Secretary, I believe that brings us to restricted item number 2, held out. Would you please read that into the record?
Restricted number 2 is the application of United Coin Machine Company doing business as Century Gaming Technologies, doing business at Twain Tavern for a restricted gaming license.
Okay. Welcome. Let's let them queue in. Welcome, Mr. Crandall. Ms. Richardson, welcome. Okay, please welcome and please state your names for the record.
Good morning, Chair Gibson. My name is Debbie Richardson. I'm the Director of Compliance for Century Gaming Technologies. I'm here today joined by, I believe, Mr. Brown is also on this morning. I don't see him. If not, I can proceed with the application if nobody else is on with me this morning. I was supposed to be being joined by Michael Crandall, the Senior VP of Siegel Group. He is should be here to talk to you regarding the operations of the establishment.
He's here.
Hi, sorry, I was on mute. Can you guys hear me?
We can.
All right.
Now I can hear you. Yeah. There we go. Hi, Michael.
Hi, how are you?
Okay, with that, please give us an overview of this item, if you would.
All right, this item came to us approximately mid-March. We were asked to, at that time, what I thought would be to do a one-day operation. I was then told that this would need to be a full-blown application for restricted license at the tavern formerly known as Maddie's, which is now Twain Market, or I'm sorry, Twain Tavern. So I went ahead and based on discussions that Mr. Brown had with the board, I went ahead and filed as quickly as possible an application for restricted gaming at the property, which, like I said, we had filed as timely as we possibly could under the circumstances. And at this point in time, I'd really like to say thank you so much to Applicant Services for all their hard work, and especially to Agent David Bradford for, accepting all my quick emails and putting this thing together as fast as he did. This is simply, it is a straightforward space lease application. We will open the property before the 9th. So our intention is on Friday the 7th, we will open the property, we will conduct gaming for that day, and then we will seek a temporary closure of the property moving forward. So that's about where we stand at this point in time.
Okay, thank you, Ms. Richardson. I appreciate that overview. Mr. Crandall, welcome.
Thank you. Thank you for having me.
So with the space lease, we normally would not hold it out and have discussion on it, but this one was unique because of the timeline. Would you please help us understand why this application was filed so late?
Yes, sir. So we had a tenant in the property property for a long time, and a little before the pandemic hit, the tenant moved out. And to be completely honest, we dropped the ball throughout the pandemic. For some reason, we didn't realize the expiration date to get the gaming application in, and we take full responsibility for that, and we apologize. And then when it came to light in the last month, we scrambled and got Century on board, and we appreciate them, and we appreciate the board working with us, and we're moving as quickly as possible to grandfather the license in and also get the property reopened. That our goal in the coming months is to find a tenant on the property and get it opened as quickly as possible.
Okay, thank you. And so if you wouldn't mind explaining what kind of grandfather provision are you trying to preserve here?
The restricted gaming provision, I believe. Is that right, Debbie?
Yeah, it's the space lease restricted for 15 games, tavern, 15 games or less.
Okay. The reason I asked the question, Mr. Crandall, is we want to make sure that going forward, you understand the rules, that you've sought out competent counsel, and that you're seeking their advice and following it.
Absolutely. And I can assure you, something like this is never going to happen again. We usually have all our ducks in a row and we're organized, and this one I take full responsibility for on behalf of our company, and we dropped the ball on it, and we do understand the rules, and it will not happen again.
Okay. Mr. McKella, Senior DAG McKella, would you please explain the provisions or the nuances of this grandfather provision?
Yes, Chair Gibson. It's an 18-month ceasing gaming operations grandfather provision that if gaming were to cease for that period, then this establishment would have to come into compliance with certain restricted tavern rules, like embedding the machines in the bar top, having 2,500 square feet of space available for patron use, having a restaurant, things of that nature. So if they did not maintain this grandfather, they would have to meet those requirements.
Okay, thank you, Mr. McKella. And Mr. Crandall, would it be possible for you, is this location within a strip mall of some kind?
Yeah, it's kind of it's within a small strip mall.
And so, I mean, essentially, you wouldn't be able to build out to 2,500 square feet. Is that correct?
Yeah, correct. It's kind of a little standalone location that is within a very small strip mall, to call it that.
Okay. All right. All right. I'll turn it over to my colleagues for any questions if they have any. Okay, Member Watkins.
I don't have any further questions.
Okay. And my other colleague, Member Katsaros, has nodded his head. He said he did not have questions.
Yeah,
the background is.
Looks like my microphone wasn't working. No, I didn't have any other questions either. Thank you.
Okay, thank you. Well, there was nothing in the background that was problematic. The only reason for the call forward was just to make sure you understand that this was exceptional. We don't normally do this, and I don't expect that we'll ever do it again, or we'll try not to. But under the circumstances, and given the fact that it'd be impossible, or in theory impossible, for you to build out 2,500 square feet, we were trying to help you. So with that, I would ask my colleagues if they would be willing to consider a motion.
I am indeed. Chair Gibson, I move to recommend approval of restricted item number 2 as read into the record by Secretary Bell.
Okay, Madam Secretary.
Member Watkins,
Aye.
Member Katsaros,
Aye.
Chair Gibson.
Aye. Thank you very much. Thank you for appearing.
Thank
Thank
you.
you so much, and we really appreciate it. Thank you.
Okay, take care. All right. Madam Secretary, would you please read into the record item number 3?
Restricted number 3 is the application of Smoke Ranch Enterprises, Inc., doing business as Lucky Spot for a restricted gaming license, and the applications of Rapinder Chima and the Chima Holding Trust for licensure as sole officer, director, and sole shareholder, registration as a holding company, and or a finding of suitability as an administrative trustee, investment trustee, benefits trustee, and beneficiary as noted on the agenda.
Okay, thank you. Let's look and queue in. Mr. Donato, welcome.
Good morning, Mr. Chairman.
Let's wait for your client to appear.
And also, Mr. Jared Kahn should be joining us as well. He's Mr. Chima's litigation attorney.
Okay. Mr. Chima. Mr. Kahn is here. I see him. Mr. Chima. Mr. Chima, you need to turn on your microphone and your video, please.
Hi, sorry about that. I believe I'm connected now.
Okay, you are. Well, I mean, let's have you give us an overview.
Yes, I understand there may have been some, first of all, Jeff Donato with Argentum here. On behalf of the applicant, with me today is Mr. Chima, the applicant himself, and also joining us today by Zoom is Mr. Jared Kahn, which is Mr. Chima's litigation attorney. So I do understand there may have been some items of interest with the application. So we do have affirmative presentation. And with your permission, Mr. Chairman, I would like to briefly explain the application and how we got here today. Then have Mr. Kahn provide some information related to the 2 litigation cases. And lastly, have Mr. Chima provide some information about himself.
Okay, we'll start there, please.
Thank you. On or about January 5th of 2018, the application for a restricted gaming license for a convenience store known as Lucky Spot was submitted with the Gaming Control Board. As part of that application, Mr. Chima was seeking licensure as sole officer, director, and shareholder. On June 6th of 2018, the board recommended a 2-year limited license. The reason for the limited license was due to one unsatisfied judgment from litigation case involving Jazz Beer Sing, which we will refer to as the Sing case. On June 21st, 2018, the commission followed the board's recommendation and approved a limited license to expire at midnight on the June 2020 commission meeting. Subsequent to the approval of the limited and restricted license, Mr. Chima was involved in a legal matter with Miss Paige Worthen, which we will refer to as the Worthen cases. On or about December 4th, 2019, we filed the application for review of the limited restricted license for Lucky Spot. As part of that application for review of the limited restricted license, we fully disclosed the Worthen cases on Mr. Chima's personal history record. On May 5th of 2020, we gave notice to Agent Tan that Mr. Chima's litigation attorney was experiencing delays in scheduling court dates to resolve the Sing and Worthen cases due in substantial part to the COVID-19 pandemic. As part of the notice we gave to Agent Tan on May 5th of 2020, we voluntarily requested to pull the application to review the limited gaming license from the June 2020 agenda. By pulling the application from the agenda, we knew it would cause the gaming license to lapse and the gaming operations to cease at the store. However, Mr. Chima felt that this was the prudent approach to give him more time to address the open items before coming back before the board and commission. As a result, Mr. Chima has been without gaming at the store since June of 2020. Subsequent to pulling the application from the June 2020 agenda, Mr. Chima formed a trust known as the Chima Holding Trust. On September 17th, 2020, we gave notice to the Agent Tan, requested the pending application be amended to register the trust as a holding company and for licensure as sole shareholder, and for Mr. Chima to be found suitable as sole trustee of the trust. Since the time of filing the request to amend the application, we have been in constant contact and communication with Agent Tan to provide her regular updates on the Sing and Worthen cases. Some of the relevant communications included the following. On November 11th, 2020, we emailed Agent Tan to inform her the Nevada District Court dismissed and vacated the judgment against Mr. Chima in the Sing case. On December 23rd, 2020, we emailed Agent Tan to inform her of the arbitration award in the Worthen cases was converted to a final judgment, but Ms. Worthen then, through her attorney, filed for a trial de novo in an effort to erase the arbitration award and begin a new trial. On January 19th, 2021, we emailed Agent Tan to inform her the judge granted Mr. Chima's motion to strike the request for a trial de novo and that Ms. Worthen then filed a motion for reconsideration. On March 11th, 2021, we emailed Agent Tan to provide her a copy of the order denying Ms. Worthen's motion for reconsideration. In providing the order denying the motion for reconsideration, we were informed by Agent Tan that we missed the April agenda, but the application would be placed on the May 2020 agenda. On April 6th, 2021, Ms. Worthen, through her attorney, then filed a notice of appeal, and we immediately notified Agent Tan of the same. But we respectfully request that the application remain on the 2020 agenda. So here we are today. And with that brief overview, I'd like to turn it over to Mr. Khan that can provide you more detailed information about the two litigation cases.
Okay, thank you, Mr. Donato. Mr. Khan, please go ahead.
Good morning, Chair Gibson and members of the board. My name is Jared Khan. I represent Mr. Chima in his various litigation matters that were described before you by Mr. Donato. I think what I'd like to do is kind of give a history of the cases of relevant and pertinent information so that you can understand why Mr. Chima and our law firm took the actions we did in these cases as part of defending him. I'm going to start with the Sing case. The case origin there is a promissory note that the plaintiff in that case entered into with Mr. Chima's brother in 1996. Mr. Chima did not actually receive any of those loan funds, but was included in the lawsuit by the plaintiff. Excuse me. That complaint was filed in California in June 2004. A judgment was obtained by the plaintiff there in December 2005, subsequently appealed April 2006 by Mr. Chima, who was successful on his appeal in July 2007. A new trial was then heard in California, and that was in April 2009. At that time, that was post the economic downturn, where Mr. Chima had some financial difficulties in having to defend another lawsuit and another trial while also maintaining his economic standing. Therefore, essentially, the plaintiff there almost obtained what we'd consider a default at trial. I mean, it just wasn't adequately defended. In May 2009, a judgment was entered for $44,000 in favor of the plaintiff Singh. Fast forwarding February 2011, the plaintiff Singh filed an application for foreign judgment in Nevada for $71,777.57, despite the judgment amount was only for $44,000. The original California judgment had literally blanks for interest and a blank for attorney's fees, but the plaintiff there decided on their own volition to just insert into the application for foreign judgment their own amount for interest and attorney's fees. We fast forward. Now it becomes November 2019. Mr. Chima, through our office, attempted to pay off the judgment with Mr. Singh. We reached out and had numerous conversations with Mr. Singh's counsel. And at the same time, Mr. Chima had deposited with our law firm in our trust account the full amount of $71,777.57 to be utilized as a payoff towards that judgment amount, which is still sitting in our trust account. And I'll revert back to that in just a moment. The plaintiff, however, demanded an additional $66,000 on top of the $71,000 judgment amount, asking for a total of $137,000 to release the judgment. Wrongfully so. They were seeking more attorney's fees and more interest that was not awarded. So we moved to March of 2020, where Mr. Chima authorized our law firm to file a motion for declaratory judgment and a motion to deposit the payment to satisfy the judgment with the clerk. This was because there was a true controversy at this point, whether the judgment amount was for the $71,000, whether it was for the $44,000 California judgment amount, or for what the plaintiff sought of $137,000. That court ordered in May 2020 that the judgment from California was for a total of $44,000, no interest and no attorney's fees because they were left blank. But the court noted particularly that it cannot enforce the judgment because it is not specific because of those blanks. And the court left it at that. As a result of that ruling, we filed a motion in June 2020 for a motion for relief from judgment because of that prior ruling that the judgment was not enforceable. On September 30th, 2020, the court ordered dismissal of the judgment because the enforceable judgment, because it was not an enforceable judgment, excuse me, because those sums were not certain and contained blanks. The court had indicated that the California court who rendered the original judgment could go back and fix it, but the judge further noted that the California statute of limitations for enforcement of the judgment had already expired, the 10-year enforcement. And therefore, it would leave a problem for the plaintiff. The Nevada judgment was dismissed. It was never appealed. And the California judgment is now no longer enforceable either and has expired. The plaintiff there, Singh, never went back and sought any amendment to the judgment. So that resolved the Singh matter, and the $71,000 is still held in trust. And that's because of the Worthen matter. So the Worthen history, just want to make sure we understand this case a little bit better. Mr. Chima and the plaintiff there, Paige Worthen, had nearly a 20-year friendship before a tumultuous end, essentially. The plaintiff there, Ms. Worthen, had fraudulently induced Mr. Chima into a $50,000 investment into her failing magazine. Through the lawsuit that I'll get into in a moment, we discovered other fraudulent misrepresentations by the plaintiff, including that she was acting as a representing herself as a licensed massage therapist for 15 years, but actually not ever obtaining a license to provide massage therapy. So in January 2019, Mr. Chima had hired the plaintiff to provide a massage with what he thought was a licensed massage therapist. During that massage, they had a conversation regarding Mr. Chima demanding that he get his $50,000 investment repaid to him. Plaintiff seems to start to panic. She leaves and leaves her keys in his house after she packs up all of her massage tables and everything. Cops are called to the scene because she did not want to go back in the house to just retrieve the keys. There's no further investigation. There's no charges filed. Nothing happened other than the cops asking Mr. Chima, can they please locate Miss Worthen's keys in her house? Mr. Chima thinks nothing of it. 3 months later, in March of 2019, plaintiff all of a sudden initiates a lawsuit without any prior demand or notice. And it was subject to the arbitration program that had the $50,000 jurisdictional maximum award amount. On April 10th, the plaintiff then filed a criminal complaint and excuse me, I apologize, my screen went out there, I'm sorry about that. Plaintiff initiated a criminal complaint, which was then served by mail and summons by mail. The police did not even come out to arrest Mr. Chima or interview him or investigate. Mr. Chima then entered a no contest plea on June 4th, and the case was entirely dismissed on June 5th, 2019. He was represented by attorney David Chesnoff in that matter. Excuse me. So then that was going on contemporaneous with the civil lawsuit, which Mr. Chima, while undergoing this process to try and get these things resolved, tried to seek a mandatory settlement conference with the plaintiff because there was just no discussions regarding trying to settle the case. A mandatory settlement conference was ordered in March of 2021, but clearly right before the pandemic, everything kind of shut down for certain things. Shortly thereafter, April 13, 2021, Mr. Chima makes an offer of judgment for $50,001, essentially $1 greater than the maximum amount the plaintiff could receive within the jurisdictional maximum of the arbitration program of $50,000. The offer of judgment was sent strategically because we were about to go into extensive discovery. We had two medical examinations, independent medical examinations. We had multiple depositions, a lot of discovery. After extensive discovery was undertaken, the two independent medical examinations revealed that the plaintiff was actually seeking damages for prior existing injuries that she was trying to seek treatment for, and this alleged post-traumatic stress disorder that she was alleging seemed to have been her own and her lawyer's creation, as noted by her own statements within the independent medical examination. Subpoenaed records, Facebook posts then revealed that just even days after the alleged incident in January 2019, Ms. Worthen is posting pictures without any signs of physical injuries, and she testified under oath in her deposition of the same, that the photos revealed no signs of physical injuries at all, just days after this alleged incident. So now we move forward to September 2020, where we're finally able to hold the settlement conference, and Mr. Chima actually offered the maximum amount of the jurisdictional award, $50,000, and on top of that, an extra $10,000 just to try and get this matter resolved. The plaintiff walked out of the settlement conference without even making a counteroffer. As a result of that situation, with the upcoming arbitration that was scheduled in November, Mr. Chima and myself, we requested the arbitrator to just enter judgment for the $50,000 maximum to put this to rest. It was a cost-benefit analysis that Mr. Chima had already incurred at that point over $50,000 in legal fees, He was going to continue to incur legal fees, and we wanted to expeditiously resolve the matter. So the arbitrator agreed, entered an arbitration award for $50,000. In November 2020, the plaintiff then requested a trial de novo. Mr. Chima filed a motion to strike the request for trial de novo, which was granted by Judge Atkin. He denied that request for trial de novo, saying the plaintiff participated in the arbitration proceeding in bad faith. In January of 2021, plaintiff filed a motion for reconsideration of the decision to strike the request for trial de novo. And in March 2021, Judge Barisic denied that motion for reconsideration with an extensive opinion, again finding the plaintiff participated in the arbitration proceeding in bad faith and was only entitled to the $50,000 judgment amount. Judgment was then entered immediately. Shortly thereafter, we filed a motion for attorney's fees based on the offer of judgment that they did not successfully obtain a judgment greater than our offer of judgment amount. That matter is still pending as of even 8:59 this morning. When I checked the court's docket, there still has not been an issued ruling. It was set for in chambers April 14th. Our office has spoken with the judge's clerk, and they said she has her opinion finalized. She's still working on getting it signed. Last I's dotted, T's crossed, but there should be a ruling any second. On April 6th, plaintiff did file an appeal of the order striking the request for trial de novo and the order denying the motion for reconsideration. That was just recently submitted to the Supreme Court settlement program. Briefing was suspended. We have not yet been assigned a date for a settlement conference with a Nevada Supreme Court settlement judge. And I'm going to circle back to the $71,000 that was held in trust. We have held that still in trust with the intention of paying off the judgment. The plaintiff was not interested in having the judgment paid off. Instead, they filed the appeal. And in the event we are not successful in the motion for attorney's fees, which would end up offsetting the judgment obtained in this case, because we sought a motion for attorney's fees in excess of $60,000, then the $71,000 would still be available to pay off the $50,000 judgment immediately. And at that, I think that takes a pretty extensive history and timeline of the two cases. I'm happy to address any questions that you may have, Chair, or other members of the board.
And if we could, please, if we can give Mr. Chima just a quick, just allow him some time to give some information about himself.
Hello. Can everyone hear me? Hope so. Good morning, Mr. Chairman, members of the board, and Madam Secretary. I would like to apologize in advance if I seem a bit nervous, because I truly am here. It's a pleasure to be before you today and have the opportunity to give a brief background of myself. My name is Rupinder Chima, and my nickname is Rupi. That's pretty much what I go by. After finishing university at college at the University of Southern California in 1997, I moved to Vegas in 1997 to pursue an ARCO AMPM gas station located at 2401 North Jones Boulevard. During around that time, I applied for my first gaming license around October of 1997. And I held that license all the way through January of 2017, when I eventually sold that store with no issues. I also applied for a second license for a second ARCO AMPM I purchased in 1999. And I was before the board and the commission and received that license and sometime in May of 99, and eventually sold it in August of 2004 and also had no issues. This would be my third license I'm applying for Lucky Spot, located at 6890 North Hualapai Way. As Mr. Donato has already explained, I was before in 2018 with a limited license, and that my machines actually shut off during the governor's stay-at-home orders back in March, and then they never reopened because my license elapsed in June, and we've been trying to clean up these two cases in order to come before you. Just a quick note that I've been an active member of the Asian American group for 20 years and been on the board for 8 years here in Las Vegas. I completely understand that having a gaming license is not a right, but a privilege. And I have taken being a gaming licensee for 20 plus years very seriously. I'm here today to humbly ask to have my machines turned back again on in my store. And with that, I'd like to thank you for your guys' time.
Mr. Chairman, if I can get just some closing remarks before we turn it back over to you, that would be great.
Yeah, please make it fast.
Thank you. As indicated during the presentation, the judgment in the Singh case has been dismissed and vacated. And in the Worthing case, the trial de novo was not granted nor the motion for reconsideration. And we believe the notice of appeal will be unsuccessful as well. To speak to Mr. Chima's character and as previously disclosed and discussed at the initial meeting back in 2018, Mr. Chima went through a financial hardship back in 2009 and 2010, where he was advised by legal counsel to file bankruptcy to clean up his financial situation caused by the recession. Instead of filing bankruptcy, however, Mr. Chima took full responsibility for the situation and worked diligently with the creditors to resolve his financial obligations. To speak to Mr. Chima's honesty and integrity, there were no areas of concern with the initial application filed in 2018 or the review application filed in 2019 for failures to disclose any information. Mr. Chima has been transparent, honest, and forthcoming with any and all information during this entire process. Furthermore, Mr. Chima previously held restricted gaming licenses for over 20 years without incident. Based upon the foregoing, we believe we have met the burden set forth in NRS 463-170 and have demonstrated that the applicant is of good character, honesty, and integrity. In addition, believe that we have shown the applicant has adequate business probity, competence, and experience in gaming. As such, we respectfully request the board's favorable recommendation on this application. With that, we would like to thank Agent Tan for all her hard work on this application, and we are here to answer any questions that you may have.
Okay, thank you very much, Mr. Donato. Mr. Khan, thank you for that comprehensive review of the litigation history. Appreciate that. Mr. Chima, let's circle back to you quickly. I believe you said just a moment ago, just speaking to your probity, that you graduated, you attended USC, University of Southern California, graduated from that university. Is that correct?
No, I never graduated, sir. I attended but never finished. I have about 14 units left.
Okay. So our history suggests that you attended from September 96 to looks like August of 97.
That's correct.
So a year. Okay. All right.
I attended directly out of high school. And then after I went to Notre Dame High School, then I attended in 93. And then we had the big Northridge earthquake, which I'm from. And then I moved back home during that period of time. And I went to Moore Park Junior College. And then I went back to USC. And then I moved to Las Vegas.
Okay. So you had prior units from a school in Oregon. Okay. That makes sense. Okay, thank you. And just quickly going back to you, Mr. Donato, you're an enrolled agent under Reg 10. Is that accurate?
That's correct.
Okay. One of the things that I've learned in talking to our investigators is that they had a hard time reaching Mr. Chima, that you inserted yourself every time they tried to reach out to Mr. Chima personally. Does that sound accurate to you?
But typically during the investigation process, based on my experience in working with the agents, they would contact me directly and I would coordinate the communications with the applicant and the investigator.
Okay. Do you understand, Mr. Donato, that we're trying to assess and develop a record regarding the probity, integrity, financial ability and capacity of the applicant as opposed to you?
Yes, absolutely.
Okay. It's important that our agents are able to interact with the applicant, him or herself. It's crucial. I mean, that's one of the key elements here. I'd ask you going forward, you have 5 items on our agenda today, and I'd ask you to not insert yourself when they're trying to reach the applicant directly.
Understood.
Okay. And with that, I'll pull it back to my colleagues. We're lucky to have Ms. Watkins, Member Watkins, who's was a litigator at a very fine firm, and I'm sure she has plenty of questions about the lawsuits. And so I'll turn it over to her to query that, please, Ms. Watkins.
Good morning, Mr. Donato, Mr. Khan, and Mr. Chima.
Good morning.
So I just have a few questions just for clarification purposes, is it accurate that the Singh litigation is completely closed?
Yes, that's correct, Member Watkins.
Okay. And then I'm trying to understand, you said that, if I'm understanding you correctly, that there was a foreign judgment entered and it was not in the same amount as the judgment was entered in California. So it went from $44,000 to $70-something thousand. Is that correct?
That's correct. That's correct.
And so why is it that it wasn't disputed?
Sorry, I think I may have lost you there on my screen. Member Watkins, thank you. So at the time in 2011, when the application for foreign judgment was filed, again, Mr. Chima was not in a position to have counsel dispute that during that 2011 timeframe. And it wasn't actually until we dove deep into the briefing as to what we sought in this case when we discovered that they had included the additional money from their own attorney's fees that were not awarded from the court in California, of how they got to 71,000. I think our initial take when we first were looking at it and our briefing initially was, we believed that they had added interest, post-judgment interest, to the 44,000 to get to the 71,000 because it was close. The number came to about 69,000. But in fact, during the briefing, the plaintiff there filed an opposition that indicated that they had included that differential as just their attorney's fees from the trial below that were never awarded.
Okay. And that was more just curiosity for me. Other questions I had are at what point in time did Mr. Chima determine that his investment was a fraudulent activity as described?
The magazine investment was in approximately 2000. Excuse me, I'm trying to remember the exact date. 13, around there, and the magazine that was, and the business proposal that was presented by Ms. Worthen was that she was going to be utilizing that not only for a magazine that was failing, but also to produce a reality television series. And she gave him an entire presentation on that, what the series would look like. After she received the money, she did nothing towards that, and testified as such in her deposition that no efforts were utilized towards that. She had no experience towards it. And the money essentially went to paying some other old debts of the failing magazine. And so it wasn't for several years that the magazine then finally dissolved, a couple of years thereafter. And Mr. Chima had, essentially lost his investment.
So did he determine that the investment was fraudulent before or after the incident in January 2019?
Oh, he knew it was fraudulent before then. And that's why he approached her in January 2019, demanding his money back.
Okay, but he still engaged the services of Ms. Worthen to provide a massage, is that correct? That's
correct. They were still friends. They had a friendship of, like I said, nearly 20 years. And she had provided massage services for his other family members and other friends of Mr. Chima's for years. So he engaged her for that and decided that was going to be an appropriate time to bring up the conversation of, is it possible to get my money back?
And why was that an appropriate time as opposed to other times?
Well, they were they were together in a room. It was private. Mr. Chima felt he could confront her in that room on the investment. And at that point, she really got upset. saying, how could you do this to me? I don't have that type of money to pay you back, and left.
Okay, if I could just hear from Mr. Chima about the incident that happened that night, I'd greatly appreciate that.
Sure.
Yes, so actually, Ms. Worthen was telling me that she was going to sell the domain or sell the name, that there was some new type of online platform. And by doing so, she would recoup my money, my investment. She was speaking to somebody from Australia here, there, and over a few years. She always had kind of like a different story. I didn't really press her that hard, just because we had this long-term relationship, as Mr. Khan explained. And then actually what happened is when she came over to give me a massage, she actually asked me to inject more money. And that's a time where I said, no, you promised me you would return my money. And, hey, listen, you've been making all these false promises. And if you don't, I'm going to seek legal resources in order to go after that. And that's when she got upset. But up until then, it was, I'll return your money. I never brought up any legal battles or anything of that nature. It was, I hope I've answered your question.
If you could expand on up until the point the police came.
Up until the police came?
Mhm.
Okay, so basically what happened was she came over, I got a massage, and then after my massage was done, we both sat, and she said, I would like to, kind of speak to you, about the magazine and all that. And I was thinking of the terms that she's going to, tell me how she's going to recoup my money, which were the previous prior conversations that we had. At that point, she asked for me to potentially put in more money, and she kind of wanted to revive the magazine. That's when I said, no, I'm not going to do that. And in fact, if you don't pay me, I'm going to take legal ramifications. At that point, she got very upset, and she goes, "I'm leaving." It was upstairs in my bedroom. I have like a bit of a loft area. She grabbed her big massage bed along with her bag, her purse, and proceeded to walk down the stairs. And I let her out. During that course of time, somehow, some way, her keys fell out. And then later on, about 30 minutes to an hour, the police rang the doorbell, and I was surprised to open it. And they said, well, Miss Warrington believes she left her keys in here. And then it was me and my mother, and then me and one officer went upstairs to look for the keys. And then my mom and the other officer found the keys pretty close to the front door by like an area rug. And then that was that.
Have you seen the police report?
No.
Okay. So the police report describes the situation a bit differently. So that's why I was asking you about what happened. Did you fall asleep at any point in time?
During the massage, yes.
And what happened when you woke up?
Afterwards, I woke up, I sat up, and after I sat up, I eventually proceeded to go to went to the restroom. And that's when she said she wanted to talk to me. And I, put my clothes on, and then we sat and we talked.
Okay. Thank you. I'll pass to Board Member Katsaros.
You, Board Member Watkins. Mr. Chima, good morning.
Good morning, sir.
Mr. Donato, good to see you. Mr. Khan, nice to meet you.
Pleasure.
I appreciate the overview. Likewise, I've got some questions directly for Mr. Chima, but before I go into that, I did want to get a couple of points down because I missed a bit of what Mr. Khan was going over. At the beginning of it with the Mr. Singh incident, are you saying Mr. Chima never took a loan from Mr. Singh? Did you say it was his brother? I missed that beginning part.
That's correct. The loan was to Mr. Chima's brother, and there was a document that was supposed to have essentially Rupee sign what we would interpret as a guarantee of that loan. Mr. Chima's mother also signed. But when it came out that through that litigation in California, and I wasn't counsel in that litigation, there was what appeared to be a false signature for Rupee there, and that's where on appeal that was one of the issues on appeal that overturned.
So were the other individuals named in the suit as well?
Correct. Yes.
Okay, and it sounds like everything you described here, though, it was Chima, Mr. Chima here. I don't know if the family members share the same name. So Rupee here was leading the effort. However, is that accurate?
Correct, because the plaintiff believed that Rupee had the financial wherewithal at the time in 2005 to pay back the money on behalf of his brother.
But they were equally liable under the suit.
Yes, he named all three, the brother, the mother, and Mr. Chima in the lawsuit and received a judgment against them all. Correct.
But even though his brother actually got the funds.
That's correct.
So brother gets the funds, Mr. Singh sues all three, but Rupee then leads the legal effort to combat the litigation.
Correct. I think at the time, Mr. Chima believed it, and he can explain it. It was like a matter of principle. He was going to defend himself or something where he didn't owe the money, and was being sued for a debt that his brother owed.
But he knew his brother, but he felt his brother owed the money.
I don't dispute. I don't think Mr. Chima would dispute that it was a valid loan between Mr. Singh and Rupee's brother. Correct.
And in all of this, through all the legal battle, Mr. Singh loaned money. What was the amount that he loaned to Mr. Chima's family members?
The original amount, sorry, Rupee, do you remember? I'm sorry, off the top of my head. I think
it was $40,000 that he lent to my brother.
Yeah.
Okay, so that was the $40,000 number. So at the end of all of these disputes, went from 40 to 70. I know bounced around. Mr. Singh never got a dime of this, though, right? And he incurred probably some legal fees as well, because I imagine he had representation.
That's correct. It appears that would be the situation. I'm not sure if he ever attempted to collect from Rupee's brother or not, but I don't imagine he did. And I would comment that his legal representation didn't do him justice, unfortunately, by essentially screwing up the California judgment that was then entered improperly in Nevada.
Okay, so what was the time frame again? Then loan was granted or given 1995-ish.
1996, yeah.
It was in around 96. It was a loan for $40,000. My brother was supposed to pay him back $60,000 in 6 months.
Okay.
And according to my brother, he paid back $40,000 of the $60,000.
Okay, and then it got resolved, or I guess dismissed, ultimately in 2000 and what?
So just real quick, so then the lawsuit was filed in 2004 in California. And the final judgment after the California appeal was May 2009, and then in it was not until September 30th, 2020, where the court in Nevada dismissed the judgment for being invalid.
So 24 years. Okay, I guess I did hear correctly, because I was starting to get confused on the timeline of events here over an amount of money. It would seem Mr. Chima had at some point, but understood.
Mm-hmm.
So then as we move forward, let's move on to the, is it Worthen? Miss Worthen
Correct.
Case or incident? It's known her a long time. The incident that we're talking about with regard to the police involvement is 2019. So the relationship dates back, or mid 2000s. Again, at what point did he give $50,000 for an investment in her venture?
It was probably somewhere around 13.
2013-ish. Okay. And what was the terms of the contract that you signed with her when you gave her these funds?
I was 40% of the company, and she was 50%, and then another law firm out of Santa Monica was 10%.
Okay, and then you had that documented via written contract, correct?
Yes.
Okay. And
it was called, I think, Rusty Productions LLC, named after her brother that passed away.
And did the terms of the contract require that she pay some sort of monthly, yearly dividends or?
No, there was not.
Okay, so it was, here's 50 grand. Well, tell me, what was the contract for then?
Basically, I would invest $50,000 to get 40% equity. Originally, it was 50% equity, but then I brought in another a law firm to kind of help out with some of the patent stuff and some of the potential legal work. So they were kind of I gave them, they became 10% right off the get-go.
Okay, but what was the intent of the contract? You're giving money in a venture in your hopes of?
She was proposing, or she said that she was in the process of doing a reality show, and that's when myself and a friend of mine, Darren Enestein, who's an attorney, felt that this might be a lucrative venture.
Had she ever done a reality show or magazine?
No, she never did.
Okay, because
Yes.
I get confused when you say it was a scam ultimately.
Well, obviously, I didn't think it was. I didn't think it was a scam initially, and I kind of thought it was a reasonable idea. And then once Darren Enestein got involved, I figured, well, geez, he's got better, perception than I do. That maybe this thing can probably go somewhere. At the time, the UFC reality show was very, very big, and that's what it was kind of hedging off of. And I think it's called The Ultimate Fighter or whatever it was. And so at that time, like I said, it seemed like a good idea, and hence, I invested the money.
Okay. She had no experience in this though? She was a masseuse up to this point, or did she have some experience in producing television shows?
No, she had no experience or nothing. She claimed she had the contacts, and Enestein felt that he's out of Santa Monica, felt that he can maybe open some doors up too, but that nothing ever came to fruition.
Okay, but you had $50,000 at your disposal at that point. How did you get to a point where you're able to just throw $50,000 to somebody who has zero experience in doing this, and you felt like there's a lot of upside here potential, but you weren't worried about the downside, I guess? What was your career path at that point? Because I remember Mr. Khan mentioned a minute ago, in 2011, you didn't have the wherewithal to be able to pay off these funds. 2 years later, now we have $50,000 that we're ready to give to somebody who has zero experience in producing a reality show. But now you got money.
Right. So basically, most of my downfall came in around 2008, 2009. And then after what we'll call the Great Recession, or at that given time, and so a majority of my funds were lost in real estate, in property where I put down money but wasn't able to build. And then eventually, after a few years later, I started recouping a little bit. And during that process, I had over 50 liens that was disclosed, and 50 plus liens, and I was slowly digging myself out of a hole. And for some reason, I thought that the upside was big, and hence invested the money thinking that this might solve something, a good chunk of my financial problems. But during that time, from 10, 11 on, I just did nothing but to rebuild my financial position all the way through today.
And I'm trying to parallel your reaction and your actions with the Miss Wharton case versus the actions with the Mr. Singh case. Okay, understood. Let's go to the actual incident now. 2019. I get what you've just mentioned there. I don't need to have it restated. But the police report, as Ms. Watkins mentioned, paints a little bit of a different picture, and it also paints a picture that there were some other witnesses there. But what you suggested was that you had a very kind conversation with Ms. Wharton. At a certain point, there was an impasse. She decides to leave. Keys were accidentally left behind, correct?
Correct.
So she's now out in the street. You said the police came an hour later. According to the report, or according to the information I have, she called 911. So I'm trying to square the fact that she's outside now, just had a pleasant conversation with you. She leaves the keys in the house, yet she decides to call 911 in order to retrieve keys from someone who she had a cordial conversation with.
Right. I don't know what happened once she left the house, because I was inside the house. But two officers came, and there was no incident, no nothing. I mean, as Mr. Chesnoff said, he goes, you know, if you struck somebody 14 times, they would have some bruising or something would happen. She didn't file her police report until I believe the next day or after that, and even I didn't even know about that until I got summons.
Actually, she gave a voluntary statement. It seems on the exact same night the police were actually called. This is from the materials I'm looking at, if I'm not mistaken. But nevertheless, the information I have in front of me suggests that other people saw and needed to help you get away from Paige as they came out of their house. So I'm getting a different picture for the police report. I will say, to your credit, it's not as if the police have suggested what happens. They're documenting the information as being told to them, right? Because they're coming on late in the scene, as you said, half hour later, whatever that time frame was. But they did suggest that the neighbors had heard a ruckus outside of sort and came towards you in order to get you away from them. And I will note, these are your neighbors, not her neighbors either. So, you know, perhaps there would be a bias in your favor. But okay. Where all this starts with my questioning is the information I had with the report is that you weren't very responsive at all in answering any questions from our investigators. That does speak to your integrity, frankly, for me. And I appreciate Mr. Donato does a wonderful job, and he can certainly answer questions and so forth. But when we're getting crickets back when we have questions directly to you, it doesn't start very well for you. And that's usually absolutely not the case, how it works. In fact, I would say usually it's very odd that our investigators haven't really talked to you at all through this. So this presumably is your first time you're engaging with us since the start of the investigation. So anyways, I will yield at this point, Mr. Chairman.
Okay, thank you. So just looking back at I mean, I don't want to relitigate your last appearance in front of the control board, but I'll note this. So it looks like the last time you were in front of Chairwoman Harris, last time you were up for licensing, you made a statement that to the investigators that you had perfect credit prior to 2009, and Chairwoman Harris disputed that. It appears that you had debts that were ultimately settled, but you had debts that were outstanding. And it seems that there might be a cycle here. So talk to me about your financial history over the past 20 years. Have you found yourself in trouble, sort of, you know, by accruing debt over periods of time and then either just discharging it through bankruptcy, or it's settling debt and having it happen again and again? Or is that an inaccurate sort of assessment of where you're at?
That's inaccurate, actually. Since I've been, once I reached Las Vegas in 1997, I did borrow money from friends and family to acquire my original gas station. And then I did pay them back, and I did very well in when I came here. I superseded my expectations. A lot of it had to do, I was at the right place at the right time. We were the fastest growing city, for 7 years in a row. I made a reasonable amount of money in real estate. And then pretty much all that went down the river around 2008, 2009. So I've had pretty much no financial issues from, let's just say, when I started my career at 21, 22, from 1997 till about 2008. 2008 was very tumultuous as I was trying to develop other gas stations and was involved in purchasing commercial property. Then after that, I've been, since that period of time, I've been trying to rebuild myself. And in that process, I never filed bankruptcy. I made deals with all my debtors, whether I paid 30 cents on the dollar or 200%, depending on who was willing to work with me. And like I said, some of them I had to pay a lot more than I actually owed because of interest and all sorts of stuff. But I cleared up everything. I was successfully able to get a $5 million SBA loan back in 2018 in order to build this particular gas station. Hopefully I don't have any more financial problems in the future. I didn't think I'll have any problems back in 2008 either. But it's not a pattern It was just one moment in time, and I've been working pretty hard to make sure it doesn't happen again.
Okay. And so the money for this new gas station that you built, I think it was around a $6 million build. Is that?
It was a little bit more than that, but yes.
Okay. It came from an SBA loan, you say?
Yes. So I sold the original store that I purchased in 1997. I sold in 2017, and I did a 1031 exchange. My proceeds were a little over $2 million. And with that money, I purchased the land at Hualapai in order to develop the site. And then I obtained a $5 million SBA loan in order to build it, to construct it. And it was a total process of about 3.5 years from the time I put the deposit on the property till the end, till we did our first transaction.
All right. Okay, I'll turn it back over to my colleagues for questions. And you have any?
I did have one follow-up question on the lapse of the license, Mr. Chima. Could you explain again, what was the thought process in letting it lapse as opposed to filing and getting the renewal in sort of the normal course of business?
So initially I was given a 2-year license, a limited license, in order for me to give me time to resolve the Jazz Beer case, as that was still pending. My store, although I got my license and I believe June of 2018, but my store didn't actually open until December of 18. It's like 6 months later. And then, so it was time to basically reach out to Jazz Beer and solve, the debt, and obviously be able to come before you and say, okay, this has been taken care of. And obviously we know the story about that. We reached out to him, and he wanted way more money, and then with Corona and all the other good stuff that kept delaying everything for our various motions, because our goal was to have the court tell us exactly what I owe and pay the court, because he wasn't accepting any money. So we thought it would be a better idea for us to take the time to resolve the issue, and then get before you.
Okay. Yeah, I'll just share my thoughts about where I'm at. Again, I was grappling with the difference in approach that you had with Mr. Singh, which, hey, lawsuits happen. I understand that. That is in no way going to shape how I think. It's more of your actions, right? And then I look at the other instance with Ms. Worth and trying to gauge what your actions were there, and then the differences of you're certainly not immune from getting to legal tangles. Why wouldn't you just take her to court and be done with it, right? Have you ever you've never since taken her to court then, right?
No, we have a counterclaim.
Well,
not the counterclaim, sorry, but you never engaged. Right. She started that first, right?
Right.
Right. So it's like you had the time to do that for 6 years, but regardless, what troubles me most is the lack of responsiveness or no responsiveness to what our investigators were requesting of you during the investigation. Where I'm at generally on this one, frankly, is more of a referral back to staff, Chair Gibson, because I wanted to take time to digest this. I've got a little more information now, at least. But that's frankly where I was, because of the things that we just discussed, and because of the new information that I believe that I have here that I did not necessarily have before, and I'm still digesting all of that.
Okay.
And
all right.
And Chair Gibson and Member Watkins and Member Katsaros, and there was a question that Member Katsaros asked of Mr. Chima, and I'd like to add just one more thing, if you don't mind. You had asked, why is there this difference essentially in the police report as to Mr. Chima's accounting essentially of the incident that night? I just want to remind the board that Mr. Chima, under oath in his deposition, vehemently denied all the allegations that were against him. The plaintiff, to this day, has never under oath, whether in a deposition or through affidavit or declaration, actually submitted a statement to those same allegations. There was never any testimony of that fact, or nothing submitted to the court that actually supported the allegations that were just made in the lawsuit. So I just wanted to make sure that was pointed out, that Mr. Chima has vehemently denied that. And if you look at the incident of the night of the when the police came there, if somebody had been hit 14 times in the face as alleged by Ms. Worthen, the police would make an arrest and let you answer questions later on charges. You know, they would say there's a domestic violence, here's an arrest, we'll deal with this later. And instead, that's not what happened. They didn't make any arrests, they didn't make any charges, and it wasn't for several months that they actually file a complaint against Mr. Chima based on her lawsuit. I just wanted to note that and just to make sure that was understood.
Well, thanks for the addition there. And I will note, I don't think I have anything that suggests being hit 14 times.
Those are the allegations.
There
Yeah,
was
those are the allegations in the
allegation.
lawsuit.
Okay, that must have been brought out in the lawsuit, which I was not looking at. I'm merely looking at voluntary statement, which was on the spot that night. It seems like 9 p.m. at night. Again, police were called for a 911. Similarly, I think if she made a false 911, and you're the attorney here, so advise me, if you call 911 without there being some sort of an emergency, is there not a repercussion against the person making that call, oftentimes at least?
There certainly are repercussions, member Gazzara, so for people making false police reports. That was not what Mr. Chima was intending to try and do with her. You know, we thought we could settle the case, make it go away, and it dragged out for years. And that's just not something that we chose to pursue as a false allegation.
Okay.
And if I could please just interject really quick about the non-responsiveness of Mr. Chima. This is the first time I'm hearing about this during this entire process, that she was, Agent Tan was not able to get a hold of her. She communicated with me directly. Everything that we have in communication was answered responsively. And this is the first time I'm hearing that she had a hard time. I mean, in fact, we have emails saying she appreciates all the responses and the timely responses and the prompt responses that we've given to her. So I'm kind of caught off guard by this whole thing about unable to reach, Mr. Chima. I know there was some requests to reach out to an ex-spouse, but Mr. Chima does not have that information. I mean, we gave the telephone number, we gave the email address, we gave every information that she ever requested for. So I am kind of caught off guard with the not able to reach Mr. Chima, or he was not responsive to her at all.
Okay, well, that's the claim. That's the claim by the investigator, and they don't lie to us. So what I'm going to do is I'm going to refer it back to staff. And Mr. Chima, what I'd say is that as the investigators interact with you, we need to get a picture from you about what's happened in your history. And with that, if it turns out that it's ready for review again, we'll put it back on an agenda and consider it again. Okay.
Understood.
Okay. So Chief Labadie, I'm going to refer this back to you. Okay, and your investigators.
Of course.
All right. Thank you. Thank you for your appearances. Thank you, Mr.
Thank you.
Khan.
Thank you.
Thank you. All right. Okay. All right. Let's let them queue out. And then, Madam Secretary, let's go on to our next item.
Your next item is restricted number 7, which are the applications of Imani Enterprises LLC doing business as Latino Mercado for restricted gaming license, and Cristabella Fernandez for licensure as sole member and manager.
Okay. Welcome, Mr. Donato. It's been
Thank you,
a
Mr.
bit.
Chairman.
It's good to see you.
Thanks.
And your client?
Yes, should be joining us by Zoom.
Okay. It looks like she's here. Ma'am, would you please turn on your camera?
Hi,
There you are. Hi, how are you?
good dear.
Welcome. Please state your names for the record, please.
Mr.
Cristabel
Chairman.
Fernandez.
Yeah, good morning, Mr. Chairman. Jeff Donato with Argentum. Good morning, members of the board, Madam Secretary. With me today is Ms. Cristabel Fernandez, which is the applicant. We do understand no areas of concern with the application, but with your permission, Mr. Chairman, I'd like to give a brief explanation of the application, have Ms. Fernandez provide some information about herself.
Okay, please go ahead.
Thank you. The application before you today is for a restricted gaming license for a convenience store known as Latino Mercado. In addition, Mr. Fernandez is seeking licensure as sole member and manager. The store is located at 2885 East Charleston Boulevard, generally located at Charleston Boulevard and Fremont Street. The store is a typical convenience store that offers, among other things, fresh foods, dairy products, a variety of beverages, including beer and wine, snack items, and gaming. This location does not have any gasoline. The store at this time will have 7 gaming devices, and the gaming will be at all times incidental to the primary business. Although the gaming license will be held by the applicant, Ms. Fernandez has entered into a 1-year service agreement with a licensed slot route operator for the gaming. After the first year, that agreement becomes month to month. The SRO is Best Buy Gaming Products. On February 7th, 2019, Ms. Fernandez attended and completed the Restricted Compliance Licensee Seminar presented by the Nevada Gaming Control Board. A copy of that attendance letter was provided to the agent during the investigation process. And with that, I'll have Ms. Fernandez provide some information about herself.
Okay, Ms. Fernandez, please go ahead. Tell us about yourself.
Hi, good morning, everybody. My name is Cristobal Fernandez. As for my background, I have 23 years of experience in management. And in those years and currently, my duties are key holder, hiring, firing, petty cash control, bank deposit, weekly scheduling, and day-to-day store operations. I also bring in new items so that the sales will increase. And basically, I'm a very hardworking person, and I want to have my own business and to grow in life and support myself and my family. So here I am.
Thank you. And as previously indicated, it is our understanding there were no areas of concern with the application. The applicant did, like we said before, enter into the service agreement with the slot route operator, attended the gaming seminar. As such, we respectfully request your approval of the application. With that, we'd like to thank Agent McEnhaney for all her hard work on this application. With that, we're here to answer any questions you may have for us.
Okay. Thank you. Thank you both for your appearances. Thank you, Ms. Fernandez in particular. The reason we asked for you to appear today is because this is your first licensing instance for gaming. We just wanted to make sure you understand that this is a front-loaded system where we do an in-depth review of the applicant, that you understand how serious this is, and that you do everything you can to follow the rules, understand them, and you're compliant going forward.
Yes, I do.
Okay. I'll turn it over to my colleagues for any additional questions if they have any.
Good morning.
Good morning.
How are you?
Good, dear.
Thank you for your presentation here today. Yeah, just to echo Chair Gibson's comments, this is your first time licensing, so we want to meet you. As indicated, there was no areas of concern, so there's nothing in your background that we really need to discuss, but we do like to hear about what plans you have for the operation and so forth. This is your first time with gaming machines. So this is part of the process here. Is there anything else you want to add with respect to your new operation here?
No, nothing else.
Okay. Well, I didn't have any other questions. I will note, Mr. Donato, there are some conditions on here, but I'll hold back to see if Member Watkins has any questions right now.
Member Watkins, do you have any questions?
Hi, it's nice to meet you, Mrs. Fernandez. And I just like to say welcome. I don't have any questions. You had a clean application, so
thank you.
That's all I have.
Thank you, dear.
Okay, with that then, Member Katsaros or Member Watkins, I'll
certainly
entertain a motion.
Those conditions I was mentioning are typical conditions for you as a new licensee here. So there's nothing untoward or whatsoever to read into it. So the conditions, I think Mr. Donato's probably already shared those with you. And so
I believe we satisfy those conditions as well. We've already entered into the service agreement and she's already completed the gaming seminar.
Okay. And you know what? Thank you for triggering my memory here. We had a discussion and this is just standard. We would, for continuity's sake, continue to have this on the license.
Yeah.
So
and we do accept those.
Okay. Chair Gibson, I move to recommend approval of restricted item number 7 as read into the record by Secretary Bell. Conditioned as follows: the licensee shall demonstrate successful completion of a regulatory compliance seminar for restricted licensees, which is deemed acceptable to the Nevada Gaming Control Board chair or the chair's designee within 60 days of the issuance of the state gaming license. This condition may be administratively extended by the Nevada Gaming Control Board chair or the chair's designee. And prior to the issuance of the state gaming license, the licensee shall enter into a service contract with a licensed slot route operator. The term of the contract shall be for at least a 1-year period of time.
Thank you very much, Madam Secretary.
Thank you very much.
Please.
Member Watkins,
Aye.
Member Katsouros,
Aye.
Chair Gibson.
Aye. Congratulations. Thank you very much.
Thank you
for
very
appearing.
much. Thank you.
Okay, good luck to you.
Thank you.
Okay, let's take a cue out and then we'll go on to our next item.
Your next item is restricted number 8, which is the application of Basunda Enterprise, Inc., doing business as 7-Eleven store number 27700 for restricted gaming license, and the application of Pawandeep Singh for licensure as sole officer, director, and shareholder.
Okay. Welcome. Please state your names for the record, please.
Good morning, Mr. Chairman, members of the board, Madam Secretary. Jeff Donato here on behalf of the applicant, who should be joining me by Zoom.
Okay, he's here. Welcome, Mr. Singh.
Good morning, sir, and good morning, all members.
Mr. Chairman.
Mr. Singh, if you would, would you please describe for us what you're applying for here?
Yes, sir. I applied for registration gaming.
Okay.
Yes, sir. And
would you tell us something about yourself? So this is your first time applying, right? Your first application. Okay.
Yes, sir.
Please.
Sir, I have done my high school in 2008, then started my nursing school in 2008 to 2010 back in India. Then I moved in United States 2010. Since 2010 to 2013, I worked in 7-Eleven. Then I started driving on the road. And the road I worked on 2013 to 2016. Besides that times, I own a truck and 2015 to 2016. And 2016, I started work as a driver in McLean Company, the local. And since 2016 to 2020, I work on in McLean Company. Then in 2020, I moved to in the business at the 7-Eleven. And I took training for 7-Eleven in 2020, and I'm here for apply for the gaming license for my 7-Eleven.
That was very good. Thank you, Mr. Singh. Mr. Donato, you had something to say?
I was just going to, if you would like me to, give a brief explanation or explain the application to you, if you would like.
Please
Very
go
good.
ahead.
The application for you today is for a restricted gaming license for 7-Eleven store number 27700. In addition, Mr. Singh is seeking licensure as sole officer, director, and shareholder. The store is located at 5110 South Maryland Parkway, generally located at the corner of Maryland Parkway and Reno between UNLV and the airport. The store, again, is a typical 7-Eleven convenience store that offers, among other things, fresh foods, hot foods, dairy products, variety of beverages, including beer and wine, snack items, gaming, and this store does have gasoline. Although a convenience store is allowed to have up to 7 gaming devices, the store at this time will only have 5 gaming devices, and the gaming will at all times be incidental to the primary business. Although the gaming license will be held by the applicant, Mr. Singh has entered into a participation agreement and will use the services of a licensed slot route operator for the gaming. The SRO in this application is Sartini Gaming. And then Mr. Singh has already provided some information about himself. So as we previously indicated, there were no areas of concern with this application. Applications for a slot route is using the slot route operator. And as such, we respectfully request your approval of this application and would like to thank Agent Bradford for all his hard work on this application.
Okay, thank you very much. So I would note for the record that there are no areas of concern in this application. So it's clean. And thank you very much for the background you provided, Mr. Singh. That's helpful to us. It's helpful to hear from the applicants. We appreciate it very much. I'll turn it over to my colleagues for any questions.
Thank you, Chair Gibson. I didn't have any questions on this. Good morning, Mr. Singh.
Good morning, sir.
Thank you for being here today.
Yes, sir.
Member Watkins?
Good morning, Mr. Singh. Your application was clean. I don't have any further questions. Thank you.
Thank you. Good morning. Thank you.
Okay, and with that, Member Katsaros, would you like to discuss the conditions and potentially make a motion? Okay.
Mr. Donato, are you familiar with the conditions on there? We have 3: surveillance system, the contract, and the seminar.
Yes.
Okay. And with that, Chair Gibson, I will make a motion. I move to recommend approval of restricted item number 8 as read into the record by Secretary Bell, conditioned as follows. The surveillance system and/or mirrors must be inspected and approved by the Nevada Gaming Control Board Enforcement Division within 60 days of issuance of the state gaming license and thereafter be maintained at or above the standard that is approved. Prior to the issuance of the state gaming license, the licensee shall enter into a service contract with a licensed slot route operator. The term of the contract shall be for at least a 1-year period of time. And lastly, the licensee shall demonstrate successful completion of a regulatory compliance seminar for restricted licensees, which is deemed acceptable to the Nevada Gaming Control Board chair or the chair's designee within 90 days of the issuance of the state gaming license. This condition may be administratively extended by the Nevada Gaming Control Board chair or the chair's designee.
Mr. Singh, do you understand those conditions?
Yes, sir.
Okay, thank you. Madam Secretary.
Member Watkins,
Aye.
Member Katsouros,
Aye.
Chair Gibson.
Aye. Thank you very much.
Thank you very much.
Mr. Singh. Appreciate
Thank
your
you.
presentation.
Thank you,
Okay.
sir.
Good luck to you.
Thank you, sir. Thank you.
Okay. Let's see here. So, Madam Secretary, our next request is an approval of a new device. Is that accurate?
That is correct. You have a request for final approval of a new device. That item is GFL QOREX submitted by TSC John Huxley.
Okay, thank you very much. We have some appearances, do we not?
Yes.
Okay. There's a bit of an echo there. You could fix that for us. And then turn your mics on, please, and you're, there you go. Mr.
There we
Miller,
go.
welcome.
Good, thank you very much. I'm here joining you today with, my name is Gerard Noller. I'm the Director of Operations, and I'm here with Ivory Abad, who is our Compliance Manager.
Okay, welcome.
Thank you.
Let's let Mr. Abad cue in. He's here, but his camera's not on.
Oh, so.
Mr. Abad, can you
Yes.
turn your please?
Hello, good morning, Chair Gibson. This is Ivory Abad. My
Miss Abad.
video is not working at this time for some reason,
Just come over here then.
but I am right next to Mr. Noller. Good morning.
Welcome, Miss Abad. Okay, tell us about your game, please.
Okay, we started a trial last year in the fall of 2020 with our, it's pronounced Corex, sorry about the abbreviation. And we had 10 terminals hooked up to our roulette wheel, and it was in the GSR Casino Resort in Reno. And we feel we've had a successful trial, and we're here today to provide you with any more information that you have on our product. And I also submitted a little PowerPoint just so that if you wanted to, or if you want us to go through it, we can do that too, of our product and some of the things that we learned through the course of the trial.
Okay, if you'd like to present the PowerPoint, that might be helpful.
Sure, let me just. Just let me know if you can see this.
We can see it. It looks like it's showing, you're sharing your screen. Okay, great.
Yeah. Can you see the beginning now? Is that good?
We can.
Okay. So I included a couple of pictures of the units before they went live. You can see our Corex terminals there with all the LEDs and the central podium unit that houses the roulette wheel and the signage. The game that we were doing at the trial was 00 Roulette. Our terminal provides the experience of traditional gaming devices such as roulette wheels, and we also deliver the benefits of electronic gaming such as ticketing and being able to use your cards as a patron card. As noted, we do have a very vibrant signage so that the equipment is very visible to all patrons and customers that decide to play it. And This configuration that you see here is kind of a round configuration, but the unit does have the flexibility to be installed in many different configurations. I have a couple in this presentation just to show you quickly.
Please.
The unit itself is a 23-inch high definition touchscreen display. And as you can see, most all the corners and armrests where you insert the vouchers and the cards, they all light up with LEDs and they're all customizable. We feel our interface to allow the customers to enter in their wagers and play the games is very straightforward and easy to use. We also provide a lot of statistics and trends on the previous games that have gone on, so that any of the patrons that wish to go back and look at those can do so. And our terminal is kind of slanted, it's kind of curved, and we tried to make it as ergonomic as possible so that the patrons feel comfortable when using our terminal. Here's some other configurations that they can be put in. It can be put into a square carousel with some larger screens. And then of course, in like a stadium game where you can have devices in the middle and then the terminals on the outside. Because we're using a roulette wheel, the game itself also has a live camera, which provides a live feed of the roulette wheel in operation from when the ball is spun all the way till the result is announced on the game. So through our trial, a month into our trial at GSR, they were initially on the Bally SDS system, and then a month after that, they migrated onto the Konami Synchro system. So we were able to trial our product on both the Bally and the Konami systems. So that was exciting for us because it gives us that flexibility. The casino was very helpful in helping us identify any potential issues or problems that came up, and worked with us all the way to ensure that we were provided as much information as possible so we could do the research and provide the solutions on our end. Just wanted to note that the item that we had that was probably the hardest was we had some bezels on the machine where when you put the ticket in, it makes sure the ticket or the voucher goes directly into the bill validator. And for some reason they were starting to crack, and then a couple of them broke, and we tried to figure out how this was being done. We thought it was maybe the incorrect screws or there was an alignment problem, but ultimately what it was is when the casino was doing the drop once a week, or whenever they did the drop, when the bill validator is tilted up so they could pull out the cassette, when they put it back in and it was being lowered back down, it was actually slamming back down, I guess due to gravity, and it was causing stress fractures on that. And I had to actually sit in the casino and watch a drop at 4 in the morning until about 6 in the morning to actually see kind of how it was being done, because all our investigation, we could not duplicate it. So we were thankful for the casino to let us participate and view in that drop so we could see exactly what was going on. And then we were able to put some counterweights on these devices. So instead of them slamming back down after they were finishing inserting the cassette, they basically had to slowly push them down. So we're grateful for the commission for letting us put patches on the software when issues were found, and to be able to validate that we were able to fix any issues. The product itself was very positively received in the casino by both the workers and the players. And we are very excited to see this product become approved so that we can install it in some more casinos in Nevada. I just have a little video here kind of showing you all the signs and the attractiveness of the LEDs. So it's, just, I don't know if you can see it or not. It comes through great on my end, but.
We can see it. Thank you.
Yeah. As far as our future roadmap, We would like to, TCS provides a lot of table equipment. We've been a supplier in the industry for a long time now. We would like to connect our Corex cabinets up to some of that equipment, namely the dice shaker. And for the dice shaker, we would like to introduce additional games such as Sick Bow and of course craps. And we also would like to connect this up to, say, a live podium with a dealer or a game that's playing Baccarat. We also look forward to having the opportunity to connect our Corex platform to some other casino systems, such as Bally's ACSC system, and of course the IGT system. Those are the kind of the core systems we're hoping to have the opportunity to connect to. And that is my brief overview of the system itself, and would like to answer any questions if you have any.
Well, thank you very much. It's a beautiful system you've put together. I appreciate the fact that you addressed the challenges that you faced during the trial, and the fact that you were able to fix them. That's the purpose of a trial. So I'd note that staff has recommended approval of your system, but before we go forward, I'd like to turn it over to could you please stop the screen sharing so I can see my colleagues? Sorry. You're okay. Please.
There we go.
Okay, thank you. All right, so I wanted to give my members, my colleagues, a chance to ask questions. Phil Katsaros is an expert in these kinds of things, and so I'd start with him. Do you have any questions, Member Katsaros?
Yeah, with all that happening, I somehow my frame got moved and I was not there, I promise. So thank you for the overview, Mr. Noller, Ms. Abad. Yeah, it looks beautiful. Given what you mentioned with the bezel issue and how you had to accommodate a fix with that, am I to assume correctly that this is the first market you're deploying these terminals in?
No, we have the terminals deployed over in the Europe market, but they were using a cashless system, so they weren't actually inserting any vouchers or bills. So this is the first one where they've actively, up and down with these units. So yes.
Okay, thank you for that, because I didn't know if this was a brand new terminal for you then. Seems not. Do you have other installs around North America?
We have an install in Canada. The installation in Canada is at a new casino, which is still actually under construction, and we installed that just prior to COVID, and then everything shut down, and it's actually still shut down because, as you know, Canada is. So we've got everything installed, but it's not up and running because the casino is not open yet. But we have it all approved by the commission up there.
This is the first then that'll be live
in North America. Yes, it's
very great. Okay, well, glad to hear that. Congratulations, because I think this is going positively here. Frankly, the report came back that it worked well. I don't think we had any hiccups other than I think there was some internal hiccup with regard to the switch over from SDS to Synchros, but not your problem. Well, it becomes your problem, but it wasn't an issue with your solution. How's that?
Yeah, well, thank you very much.
Okay. No, I didn't have any further questions. Looks very well done. Looks like a beautiful product. I wish you all the success with it.
Thank you very much.
Thank you.
Okay. Member Watkins.
Hi, it's nice to meet you.
Meet you.
So this is admittedly not my area of expertise, but just out of curiosity, how similar are the cashless machines to the ones that take cash?
Basically, it's the same terminal. They just put a blank over top of where you would normally put in a voucher or cash, and instead the patron would just put in their card that's preloaded with money, kind of like an ATM card. They would put in their card. They usually have to enter, in most cases, a PIN just to validate that it's their card, and then they can download money from the card, which is from the slot system in the back end, to the terminal. Then they play off those credits, and anything they win that goes back onto the card, and they can take that card then and move to another terminal. So it's getting popular, I think, in a lot of places because of COVID and the handling of money. So yeah, that's the way it was in our one in Europe. So that's the system that they use over there. It's a bit smaller of an installation than the Grand Sierra Resort where we installed. So
Okay, thank you for that explanation. I appreciate it. And I don't have any further questions.
Okay, thank you.
I just have one, Chair Gibson,
Please.
since Mr. Noller mentioned that. Is this a DRGT install? Did I see that with their RFID?
No,
No, which one is it? You mentioned one. I didn't know if there was numerous that you have on with cashless around Europe.
no, the only one with cashless is the one in Europe.
What system is that? It's not important. I've utilized a few of them.
It's a Bally system, but it's not the SDS or the ACSC. It's another one of their systems.
Like MCC probably. Okay.
Yes, it's MCC sounds right.
Okay.
That's handled, of course, by our Europe office, unfortunately. So I've never actually seen it, but yeah.
I was just curious since you mentioned it. Thank you.
Okay, with that, I would ask for a motion.
I can unmute now. Chair Gibson, I move to approve new game number 1 as read into the record by Secretary Bell.
Okay.
That would be
Madam
new gaming
Secretary.
device.
New gaming device number 1 as read into the record by Secretary Bell. Thank you.
Member
Please.
Watkins,
Aye.
Member Katsaros,
Aye.
Chair Gibson.
Aye. Congratulations and good luck to you.
Thank you very much for your time.
Okay, take care. All right, with that, Madam Secretary, let's read our next item into the record, please.
The next item is you have a request for final approval of a new game. That item is flushed, submitted by International Network in Advanced Gaming.
Okay. Let's let our applicants queue in.
Chairman Gibson.
Yes.
The 2 names that we have on the agenda list do not coincide with anyone waiting in the waiting room.
Okay. We did have someone from the lab, did we not, who was going to explain this game to us?
Yes, we do have representatives from technology that should be the panelists.
Okay. All right, Chief Barbie, welcome.
Good morning, Chair Gibson. Jim Barbie for the record. This game would actually have been processed through our enforcement division. So a representative potentially from our enforcement division would be able to give you some background on it.
Okay.
Good morning. This is Agent Bolter.
Welcome, Agent Bolter. Please go ahead and provide some background for us.
So this game actually was presented on December 15th, 2020 by International Network and Advanced Gaming, Sir Mark Jones. He requested the approval for Flush pursuant to NRS 4630152. Flushed is a live table game played on the variety of table configurations, but the preferred configuration is a blackjack table and can accommodate 1 to 5 players. Flushed is banked by the casino and operated by one dealer utilizing a single standard deck of 52 cards. The object of the game is to wager on how many cards it will take to fulfill a 5-card flush. The game begins with each player placing different wagers based on their predictions. After all wagers are posted, the dealer will deal 1 card at a time face up. The dealer will then place that card in the appropriate column that mirrors the suit of the card. This process will continue until 5 cards have been placed in 1 column. Flush offers an optional side wager called Switch 17. If no flush has been made within the first 16 cards, then the Switch 17 comes into play. If a player places a wager on the number 17 at the beginning of the game, and the number 17 is a winning wager, that payout will be paid out at a 35-to-1 odds. The Switch 17 allows the player to wager some or all of their winnings on that, of their original wager. Sorry, got a little confused. On the Switch 17, if the player wins, the wager gambled would be paid at 150-to-1 odds. The amount not gambled on the Switch 17 is paid out at 35-to-1 odds. So the player is wagering on the 17th card, guessing the final suit. to complete the suit. The Strat Hotel Casino and Sky Pod conducted a 56-day field trial for Flush from February 2nd to March 30th of 2021. During the initial 45-day period, the hold was identified as a 42.9%. With current COVID restrictions affecting table occupancy and restricting foot traffic at the casino floor, the decision was made to extend the field trial to March 30th of 2021, making it a 56-day field trial in lieu of a 45. The last 15 days of the field trial, the hours were adjusted and increased gameplay. With this adjustment, it actually brought the hold down to 20.7. With the increased gameplay, and the field trial was deemed a success and no patron disputes were documented. Flush obtained a variety of comments throughout the field trial and overall was determined to be a success. Based on the review and the applicant's background, the game submittal and field trial results, board staff has no concerns and recommends the approval of Flush.
Okay, thank you, Agent Bolter. This is INAG is the manufacturer distributor here and out of Minden. Is that correct?
That is correct. And I was told he was on here, but I don't see him.
Okay. Well, with that, I would, any questions of my colleagues or from my colleagues?
No, not for me.
I don't have any questions either.
Okay. Okay, with that, I'd ask for a motion.
Chair Gibson, I move to approve new game number 2 as read into the record by Secretary Bell.
Member Watkins,
Aye.
Member Katsaros,
Aye.
Chair Gibson.
Aye. Thank you very much, Agent Bolter.
Thank you for your time.
Okay. That brings us to our casino player dispute appeals. Madam Secretary.
You have 2 casino player dispute appeals. The hearing examiner recommends the agent's decision denying payment be affirmed in both cases. Item number 1 is Gil Van Bassett versus Westgate Las Vegas Resort and Casino. Item 2 is Wayne Frazier versus Harrah's Casino Hotel Las Vegas.
Okay. Let's open this for discussion. Would either of you like to discuss either of these 2 disputes?
No.
I don't have
Member
anything
Watkins?
to discuss.
Okay. All right. So with that, I would ask for a motion.
I will move to affirm the decision made by the hearing examiner denying payment to the petitioner in the matter of case number 2020-7835L.
Okay, Madam Secretary.
Member Watkins,
Aye.
Member Katsaros,
Aye.
Chair Gibson.
Aye. Thank you. All right. That brings us to our regulatory agenda item. Madam Secretary, please.
Excuse me, do we not have another dispute?
They were both read in at the same time. You can go ahead and make a motion on the second one.
Okay, because I didn't make the motion.
I'm
on
sorry.
the other. Okay,
Yeah.
My apologies there. I move to affirm the decision made by the hearing examiner denying payment to the petitioner in the matter of case number 21LV00195 as well.
Okay, Madam Secretary, please.
Member Watkins,
Aye.
Member Katsaros,
Aye.
Chair Gibson.
Aye. Thank you. And now to our regulatory agenda item.
Yes, you have 1 regulation agenda item. That item is regarding proposed amendments to Nevada Gaming Commission Regulation 5.110 as noted on the agenda.
Okay. Let's open discussion. Have we received any comment, Madam Secretary, specific to this regulation?
Yes, we have. We have received 2 public comments regarding specifically to Regulation 5.110. I read those both in at this time. The first one is, thank you for your consideration in amending the very cumbersome process of reading progressive meters on a daily basis. The proliferation of progressives in today's floor make this progressive meter reads almost a full-time job compared to the relative rarity of progressives when this regulation was first written. If you do nothing else, the amendment would be great as is. However, it'd be nice if there was a specific clarification on the starting/base amount of a progressive to be required to be read. As it is written now, it says if the payoff is 1,200 or more. However, from a theoretical perspective, almost any machine could get above 1,200 regardless of where the meter starts. It would be unfortunate to receive a write-up because a game that generally never gets above 1,200 because it starts at 400 got above that level on a random occasion and wasn't being read on the progressive log. I think it would be great if there was a $1,000 base start amount for the need to read the meter on the weekly basis. Regardless, thank you for your consideration in this very needed amendment. Kevin Sweet, the Cosmopolitan of Las Vegas. Next item, regarding proposed changes to 5.110 in-house progressive schedules, the focus and intent of the draft language is clear to lessen the burden of non-restricted licensees as it pertains to progressive logging. Draft language from 11/16/2020 aimed to limit the amount required to log at 1,200 or the W2G jackpot amount. The draft language proposed on 3/23/2021 attempts to further lessen the burden in a manner that limits the ability for the board to monitor and enforce controls over Nevada non-restricted licensees and protect the financial interest of those wagering at non-restricted locations. Specifically, the proposed amendment to 5.110 sub B should be removed entirely. It is predicated on the assertion that the board approved online slot monitoring system and metering system is able to reasonably project progressive payoff schedule amounts since previous logging every 7 days is equal to required daily logs. It is not. In order for an online system to reasonably project these values, a calculation would be made taking the coin in on the device and multiplying that by a manual input progressive factor, resulting in a projected value. If instituted, intentional fraud and unintended mistakes would continue for up to 7 days, unregulated and unmonitored. The proposed language infers that the system's predictive measures equates the daily reads. This is simply not the case, requires human intervention and is fraught with peril. Additionally, the proposed amendment to 5.1102B states non-restricted licensees may log the amount of each progressive payoff schedule not less often than once every 7 days if the progressive payoff schedule is linked to slot machines that are connected. The language does not address standalone progressives, which are not linked to another gaming device. These non-linked games are also subject to progressive logging requirements. The proposed amendment also fails to address progressive games, which are among the most popular in the industry today. As an example, many games feature secondary progressive payoff schedules and with a seed/reset value of 500 and stop incrementing at 1,000. These regularly reach or get near their cap and when won by the player, frequently in a bonus round, result in a pay above the proposed $1,200 value and require W2G. This very common situation is not contemplated by the proposed amendment, limiting the logging requirement to 1,200. This example makes a clear argument for having a lower threshold due to the fact smaller progressive payoff schedules contribute to a jackpot/W2G situations, and these progressive values will not be recorded or regulated by the proposed amendment. The motive for the regulation amendment is understandable. Our industry is producing more games with progressives than ever before. Logging these values has become more cumbersome. This fact, however, does not justify the board amending 5.110 and surrendering the audit/control intent of the regulation. The rationale for maintaining the log has not changed, mitigating potential fraud and protecting the wagerer in the state of Nevada. The proposed amendment lessens this ability and should not be amended as proposed on 3/23/2021. Christian Smith, Managing Director, Meter Image Capturing LLC. And that is all of the public comments regarding the regulation we received.
Okay, thank you, Madam Secretary. Let's bring it back for discussion. Do we have a representative of the AG's office here to talk about the amendment?
Thank you, Chair Gibson. And good morning, Chair Gibson, Member Katsaros, Member Watkins, Madam Secretary. For the record, I am John McKella with the Attorney General's Office. Chiefs Colvin, Barbie, and Douglas are also present today. Before you today for your consideration and possible recommendation to the Commission are some streamlining changes concerning the logging of progressive payoff schedules in Regulation 5.110. The draft date of the proposed changes before you today is March 23rd, 2021. You first considered changes to Regulation 5.110 on January 6th, 2021. On that date, Member Katsaros asked the proposed changes to be referred back for further discussion by board staff. Based on this discussion, proposed changes to Regulation 5.110 are before you again today to consider recommending the changes to the Commission. The proposed changes adjust the progressive logging requirements. The changes require daily recording of progressive amounts which are 1,200 or more and which are offered in conjunction with a slot machine. Further, if the progressive payoff schedule is linked to certain online slot metering systems, logging requirements could be reduced to not less often than once every 7 days. Additional discussion with your audit, technology, and tax and license divisions, and consideration of comments submitted by the public, including those two that Madam Secretary just read into the record, have suggested a few additional changes for your consideration. First, the daily logging requirement should apply to all progressives, regardless of amount, except for slot machines. For slot machines, the proposed changes would remain as in the March 23rd draft. Logging would only apply to progressive amounts which are $1,200 or more. Second, slot metering systems generally are not able to project progressive payoff schedule amounts. So this phrase in subsection 2B should be changed to records information that can be used to reasonably calculate the progressive payoff. Third, reading decreases attributable to a progressive payoff should be logged in line with the requirements of the other subsections and should not require a machine number so that it is clear this logging requirement applies to progressives beyond those offered in conjunction with the slot machine. I have provided you a draft highlighting these additional changes dated May 5th, 2021. This draft has not yet been publicly disseminated, but may be made a part of the record for this matter. The intent of all these changes is to update this regulation as well as make it easier on gaming licensees. The procedures required by the current regulation were established almost 50 years ago. Since then, slot machines have improved. State-of-the-art board-approved online metering systems are now common. Progressive displays are more advanced and much less subject to malfunction, and the board has instituted minimum internal control standards and requires internal audit procedures. The board's audit division also conducts routine and random inspections and reviews of progressive meters. These advancements have significantly mitigated the risks which existed back then. The proposed changes will substantially reduce the burden on licensees. However, they will not significantly impact the board's regulatory oversight of this area. These changes should be effective upon adoption and approval by the Commission, and are before you for your consideration and possible recommendation to the Commission. I am happy to answer any questions you may have, and I know Chiefs Colvin, Barbie, and Douglas are as well. Thank you.
Thank you. Member Katsaros, so you were the one who requested that it pull it back and there are additional changes be made to it. Would you like to talk about that and whether or not you're pleased with those?
I did indeed. Thank you for that, Chair Gibson. Yeah, at the time, the proposed changes, I think were being made or suggested by Chief Colvin of our audit division, and I was in step with what his thoughts were. I just thought we could improve upon the product that we had at that time. So we've taken it back and made several tweaks and iterations since that time. And as Senior Dag McKellar mentioned, we did take also the comments that we just received from the individuals that were read on the record by Secretary Bell to improve upon what we already had. The intent was still the same. The changes he had just made, I don't feel the need to go over all of them, but I will say from a high level, the reasons for the proposed changes here, it's multi-tiered, but in short, it's a slight reduction in the required reading of progressive meters for non-restricted operations. And it doesn't jeopardize our ability to ensure the state gets its taxes nor that players are cheated. At the same time, it helps alleviate some labor-intensive operational tasks, as was mentioned by at least one of the commentators. So we're not sacrificing control here. We're making a very moderate tweak to some existing regulations. This particular regulation, I think, went into effect in the 1970s, probably before even an online system was in place, certainly before that. It's gone through a couple of different changes since that time. But all we're doing is looking to say, okay, we've got the audit capability at the non-restricted level, and we audit those on a regular basis, whether it be during an interim audit, which happens 1 to 2 years, or a full-blown audit every 3 years. It doesn't affect the restricted operations. And therefore, we still have all the data that we need in order to ensure that we're not sacrificing or shortcutting any of our obligations here to the state or the players. So that's sort of my short take on things, but I'm happy to discuss further and answer any questions as well.
Okay, let's hear from our board chiefs. Chief Barbie, Colvin, do you have any comments?
Good morning, Chair Gibson. No, I believe the motivation behind the amendments have been adequately described by Senior Dag McKellar and Member Katsaros.
Thank you.
And I agree with what was said as well. I think the technology and the overall control environment that exists now is much different than it was in the early 70s. And I feel very comfortable that the draft that we've proposed is sufficient enough for us to give proper regulatory oversight.
Okay, thank you, Chief Colvin. Chief Douglas.
I'm also comfortable with the draft as proposed, so I don't see any issues with it.
Okay. Okay, with that, I turn it over to Member Casares has spoken. Member Watkins, do you have any questions?
I don't have any additional questions, but from my perspective, this seems to lessen burden without undermining oversight. So I agree with the comments already made as well, given new technology. So that's all I have on that. I don't have any additional questions or discussion on it.
Thank you. Okay, with that, I would ask for a motion.
Okay, and just so I'm clear, Senior Dag McKellar, the date is the 23rd?
You can do the draft date May 23rd with changes that I referenced. You can incorporate the draft dated May 5th and just work off of that draft and then publish that before the commission meeting. Or alternatively, you could have me read verbatim the changes that I have drafted to the May 23rd or March 23rd draft.
My intention was to do the first, which was to reference the date and then say taking into account the changes as described by you.
Okay, that would be sufficient. And then I would get the May 5th draft, or I would produce a new draft, which includes those comments and have that posted publicly before the commission meeting.
Understood. And with that, Chair Gibson, I will move that the board submit to the Nevada Gaming Commission for their consideration and adoption the proposed amendments to Regulation 5.110 that are before us, draft dated March 23rd, 2021, taking into account the changes as described on the record by Senior Dag McKellar, along with the recommendation that any such adoption be made effective upon Nevada Gaming Commission approval.
Okay. Thank you. Madam Secretary.
Member Watkins?
Aye.
Member Katsaros?
Aye.
Chair Gibson?
Aye. Thank you. Thank you all. Thank you, chiefs. Okay,
And
Madam Secretary.
I just wanted to say thank you to all the chiefs as well. I failed to do that at the onset. We don't see Chief Colvin and Chief Douglas here that often either, but I did want to say thank you to both of you, as well as Chief Barbie, as well as Senior Dag McKellar and all your staffs.
Were they easy to work with?
Sorry?
Were they easy to work with?
As always. I think they might suggest something otherwise about me, but nevertheless, we got this. I appreciate all the work on this. Thank you.
Okay, thank you all. All right, Madam Secretary, have we received any additional public comment by email?
No, we have not.
Okay. That will close our public comment section, and this concludes the Nevada Gaming Control Board meeting for the month of May. We are adjourned. Thank you.
Thank you. We will take a short 2-3 minute break to cue in the commissioners for the beginning of the special commission meeting.
Okay.
Thank you.
Good morning, Commissioner Cohen.
Good morning, Madam Secretary. How are you?
I'm good. How are you?
I am fine. All's well up there?
All is well. Good morning, Chairman Moran.
Good morning, Madam Secretary. How are you?
Good. We have
Good.
Commissioner Solis Rainey.
Hi, Madam Secretary. How are you?
Good morning.
Can you hear me okay?
Yes, we can.
Okay, perfect.
Good morning, Commissioner Fuchs.
Good morning.
Chairman Miranda, as soon as we have Commissioner Brown, we are able to start the meeting at your pleasure.
All right, I'm ready, Madam Secretary, to go ahead and go if my fellow commissioners are ready as well.
I'm ready. Ogana Brown here. Thank you.
Thank you. First item on your agenda is public comments. This item is placed on the agenda to give the public an opportunity to comment on gaming related matters. We did not receive any public comments regarding your special commission meeting for today.
Thank you, Madam Secretary. Then we can proceed beyond that.
The item on your special agenda today is the application of United Coin Machine Company doing business as Century Gaming Technologies, doing business at Twain Tavern for a restricted gaming license. The recommendation of the Gaming Control Board is for approval.
Very good, then. I just wanted to make a very brief statement to see if we could shorten the process. First of all, I'm pleased that the commission could hold a special meeting to assist the applicants in not losing their grandfather. I have looked at the materials submitted on this at length. I also listened to the board meeting today. I participated in the rump meeting before that. And I don't have any additional questions at this time. In watching the board go through some of the areas for the delay and the situation of the grandfather and the scope of it, I also listened to Mr. McCullough Dagg explain the grandfather at length on the record. So I don't have anything further. I would, in terms of questions beyond that, and I'm satisfied, I would turn at this time, Madam Secretary, to my fellow colleagues and see if any of them have any additional questions and or a motion on this matter.
Chair Moran, this is Commissioner Brown. I do have a quick disclosure to make.
Very well. Thank you,
Thank you.
Commissioner Brown.
And is there anyone available in connection with this presentation?
Michael Crandall on behalf of Twain Taverns.
Very good, Mr. Crandall. And after we have the disclosure made on the record, I'll allow a moment for you and Ms. Richardson to note your appearances.
Thank you so much. I will make my disclosure now, Chair Moran.
Thank
First and foremost, when I was listening to the board's hearing, there was a presentation that was made and there was a reference to a Mr. Brown. Again, my name is Ogana Brown. So if I could just get some clarification as to whom the first and last name of that Brown, because my husband is David Brown. I just want to make sure there's no issue here.
I can address that. I believe it was with regards to a Jay Brown who helped us with our liquor license on this on Twain Tavern, but not just he just handled the liquor license.
Okay, thank you, sir, for that clarification. I just want to state for the record that Jay Brown is my father-in-law. He's not my business partner. And so there's no issue because that's not in relation to this specific application. So thank you for that clarification. I just hear that name and I want to make sure I make all the appropriate disclosures. And then I have one more very quick disclosure to make in connection with this matter. Century Gaming Technologies, and just for this special hearing item, Special Gaming Technologies, there's an entity by the name of PTE Limited, is a client of Louis Roca, the firm where I am a partner, but I make this disclosure in abundance of caution. I know it's not the exact same name, and therefore I just simply wanted to state for the record, I don't believe I have the independence of judgment of a reasonable person in my position would be affected by the relationship described on the record in connection with my firm's representation of the entity Century Games PTE Limited, and I therefore intend to participate today. Deputy Attorney General Breining, is this disclosure satisfactory under NRS 281A420 and in compliance with the disclosure requirements?
Yes, Commissioner, the disclosure is adequate. Thank you.
Thank you so much.
All right, thank you, Commissioner Brown. I appreciate that disclosure on the record. And having said that, I'd ask Ms. Richardson and Mr. Crandall to note their appearances.
Good morning. For the record, Debbie Richardson, Century Gaming Technologies. I'm here to answer any questions you might have. I want to say how thankful we are that this was all handled so quickly and efficiently, and specifically want to thank the agent, David Bradford. He just turned things around in such an efficient manner. We really appreciate all the help that we were given on this.
Well, very good, Ms. Richardson. We didn't want this to get away with a problem based on the late filing, and we didn't want to see your client lose the grandfather. So we don't usually take this, I would say, way of handling our business at the commission level to have a special meeting. But on this one, we did want to accommodate you and your client. So having said that, could we have Mr. Crandall enter his appearance as well?
Good morning. For the record, Michael Crandall on behalf of Twain Tavern, and I'm the manager. And just again, I want to reiterate what Ms. Richardson said, and really appreciate you guys making the exception for us on this and having this hearing. And I apologize on behalf of my company for having this go down at the last minute, but we do really appreciate it, and I thank you all.
Good. And I had heard you make that same apology once before, and I'm satisfied with that. I also, in the board meeting, I heard Chair Gibson ask you to explain how the application got filed so late. I'm satisfied completely with your response to Chair Gibson on that, and I do not, once again, have any further questions. I'm going to turn to my colleagues again and ask if any of them have any further follow-up questions, or are we prepared for a motion to be made?
Mr. Chairman, I just have one question for Mr. Crandall. I may have to make a disclosure on this. Mr. Crandall, is the tavern or the mini mall owned by Siegel Suites?
It's not owned by Siegel Suites. Now, Siegel Suites is a brand that our parent company manages and owns, but it's a completely separate entity and a completely separate LLC.
Okay, well then, just for purposes of the record, then I do want to make a brief disclosure, is that the law firm of Cohen Johnson, is adverse to Siegel Suites in a litigation matter, certainly unrelated to this application item. I have no pecuniary interest in the outcome of this item, and based upon that, I will deliberate and cast my ballot. Deputy Attorney General Brining, is that a sufficient disclosure for purposes of this special item?
Yes, Commissioner, the disclosure is adequate.
Thank you very much.
All right, thank you, Commissioner Cohen. Any other responses from my fellow commissioners at this time? All right, not seeing any, I would ask for a motion.
Chair Moran, I'll go ahead and move for approval of restricted item number 2 as recommended by the Gaming Control Board.
Thank you, Commissioner Fuchs. Very good. We have a motion. Any discussion on the motion by the commission? Not seeing any, I'd ask Madam Secretary to call for the vote.
Commissioner Fuchs.
Aye.
Commissioner Solis Rainey.
Aye.
Commissioner Cohen.
Aye.
Commissioner Brown.
Aye.
Chairman Moran.
Aye. Very good. The motion passes, and good luck to the applicants. And we'll move forward then from here, Madam Secretary, with the next item, which I believe will be public comment.
The next item is public comment. This item is placed on the agenda to give the public an opportunity to comment on gaming related matters, and we did not receive any additional public comments during the course of this meeting.
Very good. Well, then this matter will be adjourned. I wanted to thank my colleagues for taking time out of their schedule today to have this special meeting to accommodate the applicants and their representative. And I appreciate the time you spent waiting for this item to be pulled. And thank you, Madam Secretary, for making that possible and setting this up and coordinating for us. So we will be in adjournment at this time. Thank you.
Chair Moran?
Yes.
I'm so sorry, if I could just make one very short, brief comment.
Sure, you may, of course.
Thank you. I wanted to welcome Board Member Watkins. I've known her for years in civil practice, and We are members together at the American Inn of Court with the Howard D. McKibben Inn, and she's a wonderful addition. I just wanted to take a moment to welcome her briefly, and I've seen she's done a wonderful job already getting up to speed in a very short time. So thank you for that moment. Sorry to interrupt.
No, never an interruption. And I agree with you. I'm looking forward to working with her. I was going to save the accolades for our regular commission meeting, and I'll do that at this time. And I do welcome her on board. I watched her perform the last couple of days, and I'm very excited about her being a really meaningful addition to the board. So we look forward to working together with her and the commission and the board. So thank you for bringing that up. And she'll get another bite at the apple when we do our commission meeting and later on in May. Thank you, Commissioner Brown. All right, I guess we will be in adjournment then. Thank you and have a good day.
Thank you.
Bye-bye.